Welcome to the BL Podcast Studios here in McLean, Virginia. I'm Seth Berenzweig with the firm of Berenzweig, Leonard, and I'm here with my colleague, John. John, Happy New Year.
Thank you. Same to you.
Great. Well, the justices are back in town, so now we have some new fun things to talk about. So John and I are going to just jump right on in, and we're going to talk about the infamous Bridgegate case. The famous case that came out of New Jersey and all the bare-knuckle politics and some of the really interesting legal issues that flow out of that. And I think that one of the things that we'll cover today is that I think that there are some powerful things on this case that people really aren't paying attention to. But John, just to give us some background, set the table for us on what's this case about and how do we bring the case to where we are today?
Right. What makes this case really interesting, I think, is that this case probes the line between bare-knuckle politics, or rough politics, you might say, and crime. Now, what happened in this case, and it takes us back to 2013, Governor Christie wanted the endorsement of the mayor of Fort Lee, New Jersey. And the mayor was a Democrat and didn't give him the endorsement. So some of Christie's inner circle decided they wanted some revenge against the mayor of Fort Lee.
They were not happy with him.
Right. So how were they going to do that? Well, Fort Lee is at the western end of the George Washington Bridge, which is supposedly the busiest bridge in the world. And there are 12 traffic lanes that go from Fort Lee across that bridge into Manhattan. And it has enormous amounts of traffic on it. Pursuant to a political deal made long ago, 9 of those lanes are dedicated to traffic coming off the big interstate highways, primarily 95 and Route 80, and 3 of them have been designated for traffic coming out of Fort Lee.
From Fort Lee onto the bridge.
Onto the bridge,
right,
and across into Manhattan.
Gotcha.
So that bridge is controlled by the New York, New Jersey Port Authority, which is an entity created through a bi-state agreement between New York and New Jersey. And under that agreement, the governor of New York appoints the executive director of the authority, and the governor of New Jersey appoints the deputy executive director. But the deputy does not report to the executive director. It doesn't work that way. It's not a clear hierarchical scheme. The New Jersey side of the operation operates, as a practical matter, largely independently.
Now, does the Port Authority, by the way, are they a recipient of any federal funds that would trigger some of the, federal issues that roll into this?
The Port Authority is the recipient of substantial federal funds.
Okay.
Now, Governor Christie had appointed a man named William Baroni to be the deputy executive of the Port Authority. And this, of course, is a political position. And Mr. Baroni's right-hand man was a man named Wildstein, David Wildstein. Wildstein got the idea, here's how we can make Fort Lee pay. We will move the traffic lanes on that bridge, and we will take 2 of their lanes away and give them only 1 for Fort Lee.
Bare knuckle politics. And give them a little bit of a ribbing there.
So they conferred with Christie's deputy chief of staff, Bridget Kelly, and told her about this, and she was all for it. She said, let's create some traffic problems for Fort Lee.
The famous email.
Right. So they implemented this scheme. In order to do it, they had to use the subordinate employees of the Port Authority to move the cones and to do, and what they did is, in order to convince them that this was legitimate, is they put out a cover story, not to the public, but to internally within the Port Authority, that they were doing a traffic study. And this was a traffic study to determine if the lane's configuration that had been in effect for so many years was really the right one.
Which was, of course, a complete lie and a fake, and was really just kind of a subterfuge for just kind of ribbing the mayor there because he was not on the side of Governor Christie.
Yeah, they couldn't just tell the subordinate employees, we're doing this because we want revenge against the mayor of Fort Lee. So they had to have a cover story, and that's where the lie was.
Right.
So they implemented this. It was in September of 2013. It was a Monday, and I believe it was the first day of school was starting on that day, and it was a mess. There were enormous traffic problems, and traffic was backed up through Fort Lee for blocks and blocks and blocks. There was a public outcry. There was publicity.
problems with emergency transportation
Yeah.
services.
Problems with that, and people were calling Baroni's office, and he refused to take the calls.
Right.
He just decided to let this go on, and it went on for 5 days. And eventually, the director, Mr. Foy, who was appointed by the governor of New York, learned enough about this, and he confronted Baroni. And Baroni said, can't we let this go on a little longer? This is important to Governor Christie's office.
Right.
That's the words to his effect.
Governor Christie, of course, said he was totally ignorant of the whole deal.
And he may have been. We don't know. We just don't know. But Foy said, no, we have to stop this. So he ordered the lanes to be returned to the earlier configuration of 9 and 3. Of course, in the aftermath of this, Bridget Kelly was fired. Baroni was fired. Wildstein was fired. So they were all fired.
Now, the U.S. Attorney's Office gets involved, and they start to look at throwing down some criminal charges. Is that right?
Well, they decided that firing these people wasn't enough.
Right.
And they decided they would prosecute them for fraud under the federal fraud statutes.
Right.
And that's how the case got to court. Wildstein pled guilty and cooperated. Kelly and Baroni went to trial. They were convicted. The Third Circuit upheld it, and now it's in the Supreme Court. And the issues are, do these federal fraud statutes cover this type of bare-knuckle politics involving a false statement made to cover a political motive, not for a financial motive?
So let's just jump right into it. You have this case. The Supreme Court's hearing it this week. Obviously, the people who are the defendants in this case are bad people. This is going to get a lot of attention because a lot of people are going to say that the Supreme Court has already cut back a little bit on some of the prosecutors' ability to fight public corruption. What could possibly be wrong with public corruption? Or are the prosecutors going a bridge too far, sorry I had to say it, in trying to take this perhaps political fraud and turn it into a financial criminal fraud? What do you think?
Well, that is really the issue before the court. Did the prosecutors go a bridge too far here? A little history is important here. In the 1940s, federal prosecutors, began using the fraud statutes to prosecute state and local officials for so-called honest services fraud. In 1987, the Supreme Court heard a case called McNally, and they asked the question, well, what exactly is honest services fraud, and concluded that it was just too vague a concept. It didn't give fair notice to people as to what it was. And so they held in McNally that the government couldn't use the fraud statutes for honest services fraud. Next year, the Congress enacts a statute saying, simply saying that honest services fraud can be prosecuted under the fraud statutes, but without defining what honest services fraud is.
And then just jumping ahead, the Supreme Court in the Skilling case and so forth cuts back a little bit more.
The Skilling case cut it back drastically by saying that the government cannot prosecute honest services fraud except for bribery or kickbacks. So one of the arguments made in this case by the petitioners is that the prosecution is simply trying to do an end run around these well-established Supreme Court cases. And one of the arguments they make, and it's a fairly strong argument, I think, which is that the concept of a fraudulent scheme was never intended to apply to false statements made by prosecutors by politicians concerning their motives.
Right. As opposed to, extortion, bribery, things like that, trying to use the official role of their job to try to line their pockets directly with money in direct exchange for that. Obviously, this has some huge political overtones because, while again, these defendants are not anybody that we're going to be shedding a tear over, and no one's going to say that they did the right thing. If the Supreme Court comes down and says that this kind of political bare-knuckle politics of, going in with these fraudulent explanations is going to be enough without the financial remuneration and supports the conviction, give us an example of what that can mean from a practical standpoint with respect to how prosecutors could theoretically go to the next bridge and show how that might have some serious repercussions.
Well, this could open a very wide door because politicians often give false statements as to their motives for why they're doing something. They often spin as to why they're doing something. They may, for example, a mayor may say that we're clearing the snow from a particular neighborhood because there are important transportation arteries through that neighborhood, when in fact his real motive or her real motive is to benefit the constituents in that area who voted for him or her.
Or Wilbur Ross in the census case. Wilbur Ross says that he wanted something to happen with the census in a certain regard. He said it was because the Justice Department told him to do it. As it turns out, it looked like a pretty potentially false explanation. That involved expenditure of federal funds. Why not go after Wilbur Ross, et cetera, et cetera? So, in other words, I think that what you're explaining here is that it's going to be important for people to really keep their eye on what the broad implications of this case are. I think that on one hand, it can look a little dry, and it can just look like some kind of a political curiosity that came out of New Jersey about Governor Christie without really understanding the dimensions of this. The defendants have said that there's a constitutional dimension to this, to the extent that the feds should be snooping around in state and local decisions in politics. As you're explaining, there's some real dimensions here about how other people can have federal prosecutors sniffing around and criminalizing other political decisions that may be overblown and hyperbole. So do you think that the result of this is something that's going to have broad implications?
I think it will. I think it will have broad implications. And I think that it's important for people to realize that the point of this case is not whether Bridget Kelly and Baroni and Wildstein were nice people or good people. The point is, what is the reach of these statutes enacted by Congress?
Right.
And should they be extended into this uncertain area of honest services fraud, which is not defined? And what are the limiting principles to prevent federal prosecutors from just ranging far and wide and becoming the arbiters of what they consider to be appropriate political decision-making and political statements by state and local officials?
Well, we'll have to definitely keep an eye on this case, and we will report back after we hear the word back from SCOTUS. Thanks.